Can you switch from asylum to a work visa? Your employer is willing to sponsor you for a work visa, but can you actually switch from asylum to a work visa? The answer is going to depend on a few critical factors, including how you entered, whether your status is still valid, and most importantly, what type of asylum you file. In this video, I'm going to walk you through exactly who can make this switch, who can't, and why most people in asylum might be better off pursuing a different green card instead. Hi, I'm Jake. I'm the head attorney and founder of Eligibility Law Group, one of the top-rated immigration firms in the state of Utah. If you need help with your immigration case, there's a link in the description to fill out a pre-qualification form. All right, let's go over the hard truth right up front so you know exactly where you stand. If you entered the United States without inspection, meaning you crossed the border without a visa, without going through a port of entry, you generally cannot switch to a work visa inside the United States, right? This is the case even if your employer is willing to sponsor you, even if you qualify for the job, if you were never legally admitted, inspected, or paroled. Basically means if you didn't come here legally with a visa or other legal path into the US, this path is essentially closed to you from within the United States. Another scenario, let's say you did enter legally. You came on a tourist visa, student visa, or some other temporary non-immigrant visa, but your status, your underlying I-94 has expired. Here's what most people don't realize. You cannot change to a temporary work visa, like an H-1B or an O-1, for example, if that I-94 has already expired. Your only other options at that point would be one, to leave the United States and to apply for that visa through consular processing abroad. There is a potential critical problem with that. If you leave the United States while you have a pending asylum application, you are considered to have abandoned your asylum case. It's gone. You have given it up. Another potential risk there is that as soon as you leave the United States, depending on the amount of time that you have been here without a valid status, you may be barred from returning to the U.S. for a certain period of time. If you have been in the U.S. without a status for more than 180 days, but less than 1 year, and you leave the U.S., you will be barred from returning for 3 years. If you have been in the U.S. for more than 365 days, and you leave the United States, you will be barred from returning for 10 years. So for many people who are in asylum proceedings, leaving the U.S. to get a non-immigrant visa outside the country is not just inconvenient, it would destroy your entire asylum application. There are some specific cases where it may make sense, but as a general rule, this is not going to be the desired path. All right, let's talk about who can actually switch to a work visa. Who can potentially switch from asylum to a work visa? There's really only two groups of people. Group one, you have a valid I-94. So those who enter the U.S. with a non-immigrant visa and whose I-94 is still valid. I'll give you an example. Let's say you enter the U.S. from a country experiencing serious conflict. I've had a few clients in this situation from Iran and from Palestine, for example. You come here as an international student and you file for asylum, but you're still attending school, you still have a valid I-20, and your status is technically still active. In that scenario, all else being equal, it is hypothetically possible for you to change to a different non-immigrant work visa, such as an H-1B, assuming you otherwise qualify for it. Group two, this is the much more common scenario in my experience. They're for those who filed for asylum within 180 days, all right? So these are for applicants who entered the U.S. legally. So you came here with a temporary non-immigrant visa and then filed for affirmative asylum, meaning you filed the form I-589 before your I-94 expired, or no more than 180 days after the I-94 expired. This second group is critical because of a provision of law called 245K. Essentially, it's a 180-day forgiveness provision. I'm going to talk a little bit more about that. 245K is absolutely key in understanding here because it's the critical component that allows people who have pending asylum applications to obtain green cards or obtain permanent immigrant visas through employment. Okay, so understanding the 245K provisions is very key because it helps you to understand essentially how you can qualify for a green card for one of these permanent immigrant visas, even if you have a pending asylum and potentially even if your underlying I-94 may already have been expired. I'm going to break down essentially the three paths of how this could work. So path number one, an employer-sponsored green card through the labor certification process. All right. Essentially, how this works for the EB2 or EB3 visas are that your employer, an American company, goes through a process to prove they cannot or could not find a qualified U.S. worker for the job. The legal standard here is that the employer must demonstrate they are unable to find a qualified and willing U.S. worker. It's very important that the employer follows very specific steps in demonstrating that they cannot find a qualified worker. They have to advertise the position in a number of specific outlets and test the labor market, is what the law says. Just to be honest, this process is not that quick. It can take somewhere between 2.5 and 4 years, I would say, total right now, as of January 2026. This processing time includes the Department of Labor's processing, U.S. citizenship and immigration processing, and waiting for your priority date to become current. Path number two is self-petitioning through the EB1A Extraordinary Ability category. This is the highest classification of employment-based visa in American immigration law. You don't need any employer to sponsor you. It's entirely self-sponsored. But you do need to demonstrate that you have extraordinary ability. You've got to show that you're at the very top of your field. This is commonly referred to as like the Einstein visa. A lot of people point to like Elon Musk as somebody who would be deserving of the EB1A, Shohei Ohtani, somebody like that. You don't necessarily need to be at that level, in my experience, to have this type of visa approved. But just so you're aware, this is another option of how you could obtain an immigrant visa through employment. Path number three, this is self-petitioning, again, independent of any employer, through the EB2 National Interest Waiver. So this visa is for advanced degree professionals or people with exceptional ability whose work is of substantial merit and national importance to the United States. Essentially, you need to convince the American government that the U.S. Americans, that we will benefit as a whole by allowing you to pursue your specific work, even if other qualified American workers are available. Again, no employers required here. You self-petition. So those are the three potential paths, right, through employment-based immigrant visas that you could pursue with pending asylum, again, depending on your eligibility and qualifications. Before I explain the 245K forgiveness provisions, how you can be forgiven as long as you haven't gone beyond a certain period of illegal time in the US, I need to explain how unlawful presence works. I know there's a lot of confusion about this. Unlawful presence, you can think of this synonymously with not having any legal status in the United States. Rule number one for unlawful presence: you do not accumulate unlawful presence if you are under 18 years old. The clock does not start until you turn 18. This is why a lot of children who were brought here, again, obviously before they turned 18, if they had an asylum application filed for them prior to becoming an adult, even if they are now over 18, they have not accumulated any unlawful presence. Rule number two, there are certain application types that toll unlawful presence. So filing for affirmative asylum tolls, it meaning pauses the accumulation of unlawful presence. You don't accumulate, you don't get more unlawful presence after you have filed an affirmative asylum application. Assuming it is a legitimate application, you do not accumulate this unlawful presence. So this is huge. The day you file your asylum application, this clock stops. The consequences of unlawful presence are very important to understand. I mentioned this earlier in the video. I'm just going to reiterate this, okay? If you have accumulated more than 180 days, but less than 1 year of unlawful presence, once you leave the US, you trigger a 3-year bar from coming back. If you have accumulated more than 1 year of unlawful presence, you trigger a 10-year bar. This is why timing matters so much. If you can keep your unlawful presence under 180 days because of 245K, you can have a viable path to a green card through employment in the United States. Let me explain 245K now. So normally how it works, to adjust status to a green card, to get a green card in the US, you generally need to have maintained lawful status. Now, there are some exceptions here. One of the most common ones is if you're applying for a green card based on your relationship to an immediate relative who's a US citizen. So this is why marrying a US citizen, or if you have a child who's over 21 who's a US citizen, can waive that requirement of the maintenance of lawful status. Generally, that's the rule. If you fell out of status, if your visa expired and you overstayed, you typically be barred from adjusting status in the US. 245K provides a specific forgiveness window for certain employment-based green card applicants. The requirements are you need to have an approved I-140 immigrant visa petition, and 2, you have been out of status or worked without authorization for less than 180 days total. Those are the requirements. If you meet those 2, you can adjust status, meaning change from temporary to permanent resident in the US, even if your status wasn't perfect the whole time. Here's why this matters so much for asylum applicants. When you file for affirmative asylum, you're filing tolls, right? It stops the accumulation of unlawful presence. So if you entered on a visa, your I-94 expired, and you filed for affirmative asylum within 180 days of that expiration, you stop the clock before hitting that critical threshold, right? So combined with 245K, that means you can go for an employment-based green card and adjust status, even though you technically fell out of status for a period of time. I'm going to show you a real-life example, a case study of how I've seen this work. So I had a client from Colombia, systems engineer, advanced degree. He applied for a national interest waiver. I'm going to give you the timeline of how this works. So April 2022, he enters with his family as a tourist from Colombia. Okay, October 2022, his B2 I-94, his status expires. He was technically out of status on October 2022. Okay. In January 2023, he meets me in my firm and he files for affirmative asylum application 2 days before he hired us. Okay. Right after that, we file for him to obtain an immigrant visa through a national interest waiver, through the EB2. Now, notice, he was out of status for about 90 days before filing asylum. A lot of people would look at that and think he fell out of status, he cannot adjust status anymore. Just to highlight, here's what we did. So we filed for a national interest waiver petition for him at the end of January 2023, just a few weeks after he files for asylum on his own. His national interest waiver gets approved. Right? In July of 2024, his priority date for his EB2 becomes current, and he files for adjustment of status for him and his family. In January 2025, so about a year ago, and 2 years after his priority date, he and his family get their green cards. They become permanent residents. How is this possible? It is only because of 245K. Because he had been out of status for less than 180 days before filing his asylum application stopped the accumulation of unlawful presence, right? Then once he got the approved I-140, the 245K allowed him to adjust status despite being out of status for that brief period of time. The critical issue you need to understand if you are in this scenario is timing is the most important part. If you are in affirmative asylum, you will eventually be called for an interview with USCIS, right? The problem is you have no idea when the interview is going to come. I've had some clients, I have a client right now who's been waiting more than 9 years for his asylum application interview. But I've also had clients receive interview notices in an incredibly quick period of time. I had a client last year who has H-1B, currently has H-1B, who filed for affirmative asylum on his own on the advice of a friend without telling me. And he received an interview notice in about 6 weeks from the date of that filing. The point is you don't control the timeline. I share this because if you're interested in doing this process, if you were considering this, if you're pursuing an employment-based green card through the labor certification process through a US company sponsoring you, it's going to take somewhere between 2.5 to 4 years or so total to process, right? Yes, the self-petition routes through EB1 or EB2 national interest waiver are faster, but they still take time. And again, here's why that matters. Your immigrant visa process needs to be far enough along, ideally with the approved I-140, before your asylum interview is scheduled and before your asylum interview case is adjudicated. This is because if you lose your affirmative asylum case before you have another pathway in place, you're going to be put in removal proceedings. You're going to have to go before an immigration judge, and they're going to put you in deportation proceedings. At that point, your options become much more limited. This is why if you take away nothing else from this video, if you're eligible for this employment-based process, if you have a company willing and able to sponsor you, or if you qualify for a self-petition, time's of the essence. One other point I wanted to mention is this risk calculation, right? I want to talk about the analysis between asylum and employment-based visa. Even if you have a genuine fear of persecution, right? You have legitimate facts of past persecution or reasonable fear of future persecution, approval rates for asylum are not great. These rates are going to vary depending on your country of origin and by your asylum office that you're processing in, but across the board, even people with really good cases get denied. If you compare the asylum approval rates for employment-based immigrant visas, the EB1, EB2, EB3, etc., even though those approval rates have dropped under the current administration, under the Trump administration, they're still generally better than asylum. I'm going to share one other real difference here. And that is, if you lose your affirmative asylum application, you're going to be put in removal proceedings before an immigration judge. If you lose your case again before the judge, you are getting a deportation order. You're getting deported. That's it. That's game over. Compare that to an employment-based visa. If you get your I-140 petition denied, yes, that sucks. Obviously, losing money is not great, but you can refile. You can address the issues USCIS raised, and you can try again. And you can present a stronger case, right? I share this to say the margin of error is significantly greater for employment-based visas than asylum. All right, in closing, let me just summarize what you need to know. How you entered the US determines your options here, right? If you entered without a visa, you're generally not going to have any good options here to do adjustment of status. You're eventually going to have to win your asylum case, or you're going to have to leave the United States. If your I-94 has expired, you're not going to be able to apply for a change to a temporary non-immigrant visa here in the US. You would need to leave the country if you wanted to do that. There's significant risk and downside in doing that. In most cases, it may not be worth it to you. For most people with pending asylum, an immigrant visa or a green card path is a much better path if you are actually eligible for it. Number one thing to look for is to see whether the 245K forgiveness provisions applies to you, and also to determine which of any of the employment-based visas you best qualify for. If you're in asylum proceedings and you think you might qualify for one of these, I would start working on it, or at least start putting together your documents to see whether you do. Don't wait. There's a link in the description to fill out a pre-qualification form with our firm. Happy to take a look and help you to evaluate your options. If this video was helpful at all, of course, I would appreciate any like or comment, good or bad. Love the feedback. Please feel free to drop any questions in the comment section. I will do my best to answer those, and appreciate you guys. Have a good rest of your week, and we'll talk soon.